Hi, I'm Raj Sharma. I'm one of the partners here at Stewart Sharma Harshani, one of Western Canada's largest dedicated immigration law firms. Today I wanted to talk about misrepresentation. Misrepresentation is something that we deal with on a daily basis here. And so misrepresentation, the first thing I want to tell people is that misrepresentation is defined very, very broadly in the Immigration and Refugee Protection Act. It's defined at Section 40, and there's a reason why it's defined very broadly. And the reason is that our system handles thousands, tens of thousands, hundreds of thousands of applications, and it's predicated, or it requires that people are being upfront with their immigration histories, their background, and their employment and other particulars. And so the system breaks down very quickly if individuals are misrepresenting those facts or withholding certain facts. So the first thing that people need to understand is that misrepresentation is defined broadly. It talks about misrepresentation or withholding of information directly or indirectly, and it talks about those material facts that could induce a risk or an error, or could induce an error in the administration of the act. So number one, it's very, very broad. There's very few white lies in immigration. Even if someone is telling you to make a misrepresentation or withhold certain information, be very, very careful. So my first advice to individuals is don't lie. Don't make a misrepresentation. Don't withhold material information, even if someone tells you that it's okay to do so. So what that means is that don't add or subtract family members. So we have certain individuals that they apply for permanent residency, they get married, and then they don't tell immigration. And then they get landed, and subsequently they try to sponsor their spouse, and they find out that they can't because of Regulation 117, sub 9, sub D. So don't subtract family members. Whenever there's a material change in your family composition, let immigration know. Don't add, and on that same vein, don't add family members to your application. We have many cultures, we have many different reasons why, but it might, and in their minds it might be a white lie, like, okay, let me just add on my brother's kids as my own kids on this application. Now, that's going to be a problem because immigration is wise to these sort of these scenarios or these stratagems, and so don't add, don't subtract. What are you going to do when immigration starts asking for DNA for all of your children? So, you know, a lot of people ask me, like, what is, you know, how many different types of misrepresentation are there? And I've been doing this for 15 years, so I come across almost every week a new misrepresentation, a new strategy that individuals use. So in my mind, misrepresentation is broadly classified into these sort of three broad areas. One is, I would say, the sort of typographical or an error that's not really misrepresentation. It doesn't really affect a material fact, and it's truly something that's inadvertent, immaterial. The second category, I would say, is that the sort of inadvertent misrepresentation or withholding of information, where there is a misrepresentation, but it wasn't done to get status or obtain status in Canada. So you could see this where someone qualifies. You've got an oil and gas professional from Nigeria. He qualifies to immigrate to Canada, and then he just gets married suddenly, just before he gets landed. And so he thinks, okay, well, I won't update immigration. I'll just sponsor my wife after I get landing myself, after I settle down in Canada myself. So that's a misrepresentation, but it's not done to gain an advantage under the system because they're coming to Canada anyway. The third type of lie, the third type of misrepresentation in my mind is the most egregious. That's the advertent, deliberate misrepresentation that's done to get status in Canada, i.e. you would not be here but for the misrepresentation. So this is the dependent child who's not a dependent child. This is, my parents are here, my brother has sponsored my parents, I'm 22 or 23, 24, technically I'm studying, but I'm actually married or I have a kid. I'm not under the definition of dependent child. So these individuals then come to Canada, and but for the lie, they would not be here. And then, of course, once the lie is found out, or they'd seek to sponsor their family members back home to Canada, that's where the other shoe drops. So this is unfortunate. And look, I don't know how many other misrepresentations I've seen. I've seen individuals who don't disclose criminal records from other countries, and all of a sudden that comes up. And again, this is a globalized world. This is a world where we share a lot of information, particularly with certain countries. So the first advice, of course, is always to the client: don't withhold, don't make a misrepresentation, don't think you can fool the system, because either Canada will figure it out, or intelligence agencies will figure it out, or it will come to light in some fashion, or your own friends or family will actually make a complaint against you to immigration. So this is the famous poison pen letter, and that happens more often than you would suggest. So first advice, don't do it. Second advice is what happens when it comes to light. So if you're a foreign national and you're outside of Canada and you gave these employment letters, and now immigration has called your employer and the employer says, we don't have any idea who this person is, this person doesn't work here, that's a big problem. There will be a procedural fairness letter. You may be able to address those concerns. I would suggest that you contact an immigration lawyer or someone that's well versed in these areas right away. Because if the officer is not satisfied, the only recourse you've got is the Federal Court of Canada. If you're a permanent resident, you've got one other layer of review, and that is the Immigration Appeal Division. So if there's a finding of misrepresentation, you're a permanent resident, you can address that perhaps at the Immigration Division. If you're contesting, if you're saying that this is not a misrepresentation, you can raise that at the Immigration Division. If a removal order is still issued, you can then seek humanitarian and compassionate consideration, and of course a de novo appeal at the Immigration Appeal Division, which considers the typical Ribbick and Chew factors: your establishment in Canada, your remorse over this sort of misrepresentation, the reasons for the misrepresentation, the nature of the misrepresentation, your family in Canada, the hardship, and of course the best interest of any child affected by the decision. Misrepresentation has very, very serious consequences. And again, that's done to deter individuals from doing so, because it does undermine the integrity of our immigration system. A lot of politicians have talked about Canadian values, and I don't know what Canadian values are. One Canadian value in my mind is fair play, and misrepresentation undermines that, directly contradicts that sense of fair play. So, and again, you go back to prevention as the first sort of step. But once this Rubicon has been passed, what you have to do at the IID, in my opinion, is to address the misrepresentation head on. You have to sort of acknowledge that misrepresentation, and because that's the only way you're going to get humanitarian and compassionate relief or equitable relief at the IID. In any event, misrepresentation, if it's found to be misrepresentation, whether it's you're a foreign national or permanent resident at the IID, you're looking at a 5-year inadmissibility period. So what I would suggest is, if anyone is facing this circumstance, contact someone that's well versed in this area of law. It is a complex area of law. There's a lot of jurisprudence here. There's a lot of nuance here. So it is one of those sort of areas that we deal with regularly, and it's very, very unfortunate because it has such dire consequences. So if you have, or if you are facing this, or if you have any questions regarding your application and you're concerned about the possibility of misrepresentation, feel free to contact any of the lawyers at Stewart Sharma Harshani. You can call us at 403-705-3398 or email us at info@sshLaw.ca. Thank you very much.